Bussandra and City of London Corporation.
Ms. Hutchings.
May it please your lordships and your ladyship, I appear for the appellant in this matter, together with Messrs. Calsavara and Sirica. My learned friend, Miss Davies, King's Counsel, appears with Mr. Marshall Williams. I hope you've got everything.
I would think we have. We seem to have.
Well, if there's anything you don't have, then obviously let me know at the present moment and I'll arrange for it to be handed up. So, roadmap. I intend to make my submissions in 5 sections. First, to address the meaning of deliberately, section 191, subsection 1 of the Housing Act 1996. There's been a helpful, for my part at least, I would say a helpful exchange of skeletons between myself and my own friend, Ms. Davies. So I'm going to try and focus on 5 propositions which I advance before responding to the respondent's case on the meaning of deliberately set out in the respondent's notice, namely that if disability has a significant role to play in the act or omission, it is not deliberate. So, second section of my submissions, I'm going to try to highlight relevant parts of the factual background. Third section, I'll deal with the rest of ground 1, insofar as there's anything left in it. Fourth section, I'll deal with ground 2, and fifth, I'll deal with ground 5. And in referring to the numbers of the grounds, I'm referring for convenience to their numbers in the court below.
Yes.
Otherwise, it gets a bit confusing. So, first section, meaning of deliberately, in section 191, subsection 1 of the Housing Act 1996. Your lordships and your ladyship should have 2 bundles of authorities. Within the original bundle, divider 1, page 14, those are the provisions.
Yeah.
So subsection 1, a person becomes...
Sorry, could you, electronically there's no tab numbers. Can you give me a page number?
Yes, sorry, 14.
Oh, page 14, what's that?
Yes. I'll try and make clear both, because I'm aware, particularly if one spend a long time in the rolls building, it's all done electronically. So, page 14, original authorities. A person becomes homeless intentionally if he deliberately does or fails to do anything, in consequence of which he ceases to occupy accommodation which is available for his occupation and which it would have been reasonable for him to continue to occupy. And then, so far as material for present purposes, we also have subsection 2. For the purposes of subsection 1, an act or omission in good faith on the part of a person who is unaware of any relevant fact shall not be treated as deliberate. And what is the relevance of that? Well, the answer is, if one turns back to page 11, section 190, subsection 2, sets out the duty owed to a person who's found to be homeless, eligible, but to have become homeless intentionally and has a priority need. And so subsection C paragraph C in subsection 1 relates to the initial duty, which is the Homelessness Reduction Act changes. And you look at my lady can see that the duty under subsection 2 is a limited duty to secure that accommodation is available for such a period as they consider will give him a reasonable opportunity to securing accommodation for his occupation and to provide with advice and assistance. And my learned friend and I did a case against each other very long ago about this provision. On the other hand, if the local authority are not satisfied that the applicant became homeless intentionally, in the same circumstances, it's page 17, the main housing duty. So, your lordship and your ladyship C, subsection 1, where it applies, and in particular, paragraph A, Roman 2, are not satisfied that the applicant became homeless intentionally, and the duties in subsection 2, which is a broader duty to secure that accommodation is available for occupation by the applicant until it ceases under one of those provisions. And I feel in the skeleton, I referred you to page 6, section 176. And one would almost be remiss not referring to this in terms of, it's not relevant in this case, but the availability of accommodation means it must be available for occupation by the applicant together with any other person who normally resides with him as a member of his family, and any other person who might reasonably be expected to reside with him. And of course, that's the Cappy Come Home point. That's why the original Housing Homeless Persons Act 1977 was brought into force, to ensure that homeless families were housed together. So in my skeleton paragraph 3, I've just set out, paragraphs 3 and 4, I've set out an analysis of the different issues that can arise, which I don't expect is controversial. Point being that in the present appeal, there are 2 issues that are live. Was there a deliberate act or omission? And would it have been reasonable for the applicant to continue to occupy the accommodation, which I've labelled the RCO issue? So, in this case, was Mr. Bussandra serving the notice to terminate his tenancy dated the 12th of January 2016 a deliberate act? And secondly, would it have been reasonable for Mr. Bussandra to have continued to occupy what I've labelled Brighton Flat? So just briefly, principles of interpretation within the supplementary bundle of authorities. We've got a recent pronouncement from the Supreme Court, page 150, tab 8, for those who have tabs, ratified from the Secretary of State for Housing, Communities and Local Government, the crematorium case. So what I'm interested in is just the propositions within Lord Hamblin's judgment. Firstly, page 160, paragraphs 53 and 54, a concise summary of the current approach towards statutory interpretation, meanings of words, in the light of their context and purpose. And the well-known statement by Lord Bingham in Quinterville, for its task, give effect to Parliament's purpose. So the controversial provision should be read in the context of the statute as whole and in the historical context. Next, because it may be of some significance, paragraphs 59 to 61 on pages 161 and 162 in summary, statutory guidance has about the same status as a textbook, and how persuasive it is depends on the quality of its reasoning. So in terms of purpose, we have a statement of its purpose from one of the House of Lords judges, which has subsequently been cited with approval by the whole Supreme Court. So that's in the case of Dean and Wandsworth London Borough Council. It begins at page 3 in the supplementary bundle of authorities. It was a rent arrears case. And in the face of mounting arrears, the applicant left the accommodation and the holding, you can see in the head note that the hypothetical eviction, which might have taken place anyway, did not mean that the applicant did not become homeless intentionally. So that's just the background, but the proposition I'm interested in is at pages 25, 26. This is Lord Lowry. So it's really from B to F, and I should probably just sit down and invite you.
You'd like us to read that paragraph?
Probably worthwhile reading. So the main point is on the right-hand side, slightly above the letter D, clearly Parliament did not intend to punish persons for becoming homeless intentionally. The object was to lay down conditions for retaining priority and thereby to discourage persons from so acting as to increase the already heavy burden on housing authorities. And the method was to postpone the claims of those who so acted, and to give their places in the queue to those who did not. And it's sometimes summarised by saying it's queue jumping. That very much focuses on, as it were, fairness to the applicant. From a systemic point of view, it's to keep the numbers down.
The consequences are different now than are they to what they were then? Because it's not about placing a priority in the queue anymore, is it? It's about the nature of the assistance you're given.
The provisions were not materially different.
But it isn't about where you are in the queue, is it?
Well, perhaps the wider context is that local housing authorities have what are now called housing allocation schemes for allocating permanent housing. And if you're accepted to be owed the main housing duty, you're likely to jump up that list in the waiting list for permanent housing. I think in particular, if I'm not mistaken, Lord Wilberforce discusses that in some detail in terms of the policy of the Act, and his words are something like, some inroads there are bound to be into the local authority's discretion to allocate permanent accommodation, but it's kept within limits. So it's that kind of this wider discussion that's going on here. So the answer is no, that's a turn of phrase. It's within the wider context of how this fits into the allocation of permanent housing. footnote to that is when the Housing Homeless Persons Act 1977 was originally enacted, it was the understanding that if you owed the main housing duty, that meant that you were entitled to permanent accommodation with a secure tenancy. It wasn't until, and that was actually written into the Code of Guidance, it wasn't until the House of Lords decision in the case called Ex parte Awua, Lord Cochrane's well-known judgment in that case, that link was severed, shortly followed by the legislative separation of temporary accommodation, Part 7, permanent accommodation, Part 6. So I hope that answers my Lord's question. My basic submission is the purpose of this provision is pour encourager les autres. It's to prevent people from walking out of accommodation if they've got a priority need, and thereby imposing a duty on the local housing authority to house them. And Lord Lowry is quite clear about that, in the sense it wasn't about these homeless applicants queue jumping. He says that at page 679G, second sentence, it's the sad misfortune of the appellant that through panicking about the debt of rates, they became intentionally homeless contrary to advice. And then over the page, at the end of Lord Larry's speech, there is to my mind no question here of queue jumping or other unmeritorious conduct, but by applying the law as I see it to the facts, coerced to hold, they lost their priority by becoming homeless in a relevant way. So it's not about the kind of queue jumping in the sense of abuse of the system. It's about a provision which places limits on the local housing authorities' heavy obligations, as they're described, towards homeless people. So that purpose, general principles, purpose out of the way, my first proposition, I suspect, is actually not going to be controversial, but it's helpful to have a structure, is it deliberately governs the act or omission, not the consequence. And within the original bundle of authorities, we provided the Court of Appeal's decision in Devonport and Salford City Council, page 32, that your lordships and your ladyship asked for a copy which is logically anterior of Robinson and Corvey Borough Council, 1982, 1 All England, 726.
The more so, actually, this is obviously my request, because when you read Lord Justice Waller,
You can't make sense of it.
quotes doesn't make sense. Yes.
Yeah, absolutely. So I intend to briefly refer to Robinson.
Yep.
So second, and this is separate from the bundles of authorities, it's a rent arrears case with a twist in the report 727. So there, it was I think a 3-year fixed term secure tenancy would have been. So there were forfeiture proceedings, but those didn't result in possession in the end. But there was a long history of suspended warrants and so forth. Page 727 below letter B, we kind of get to the nub of it. The Housing Society, in light of the kind of checkered rent history, terminated the tenancy by notice to quit. And that's what resulted in them ceasing to occupy the accommodation. And the main argument was that the homeless applicants intended the Housing Society had been unreasonable in serving those interests. But you see the first holding how the argument developed. Deliberate act, the reasonable result of which was eviction. And His Honour Judge Goodall, sitting as a High Court judge, took up that issue, page 729 of the report. Sorry, I'm just taking you to the provisions at the time so you can see they were the same. Section 191, the below letter G. You can see that subsection 1 was materially the same as 1911. 17.2 no longer exists. That's becoming threatened with homelessness intentionally. Subsection 3 is the analogue to 1912. And over the page, the judge considered the meaning of the word deliberately. That's page 730 in the report. Second paragraph, first paragraph that begins on that page, sets out the question to deliberately apply simply to the act or omission, or governs everything, therefore connotes an intention to become homeless. And then there was the reason why that arose as an argument was the dictum of the Master of the Rolls, Lord Denning, in a case, the Slough Borough Council case. Yes, right. So many people would have thought that Miss Jack's conduct, however deplorable, was not deliberate in the sense required. She did not deliberately do anything to get herself turned out, hence the argument. But the judge came to the clear conclusion that the word deliberately governs only the act or omission. And then just to help to make sense of Lord Justice Waller later on, the end of that paragraph, that's just opposite letter F, it seems to me difficult to apply that subsection to the concept that deliberate and the adverb deliberately governs homelessness. And that's what Lord Justice Waller. And the other view is that a person is not intentionally homeless unless he has either wanted to be homeless or done something that would inevitably lead to homelessness, or, to use Lord Denning, Master of Rolls' word, deliberately done something to get himself turned out. I think the whole wording of the two subsections, coupled with subsection 3, points to a much wider construction. Just pausing there, wider construction means that deliberately is wider. In other words, more people are caught by the intentionally homelessness provisions than under the construction advanced on behalf of the homeless applicants. Because you only need an intention to do the act or omission. You don't need an intention also that the consequence will happen, which would be a narrower class. And there we have it. In my judgment, if a person deliberately does an act, the reasonable result of which is his eviction, and the act is in fact the cause of his eviction, then he becomes homeless intentionally. Which been adopted subsequently, and my basic submission is the Court of Appeal approved that decision in the next case we're going to look at, the Devonport case, page 32 in the original authorities bundle. And page 33 at the end of the summary of the facts, towards the right-hand side, accordingly, so above the holding, accordingly, the court granted the application for judicial review. On the authorities' appeal, the applicants argued that they could not be held homeless intentionally unless the authority could be satisfied that they had shown an actual intention to become homeless. So it's the Denning dictum again being relied on. And what did the court make of that? We see within the judgment of Lord Justice Fox, page 41. After having quoted the same dictum from Lord Denning, perhaps you can just read up until the immediate cause.
Yes.
So that's the proposition that this case is always cited for. Lord Justice Waller delivered a concurring judgment, and the material part, page 46. So the first paragraph that begins on that page, we don't need to look at the first two sentences. It was argued before us. And then the reference to the Denning dictum. I'm satisfied from a consideration of the whole of the section and subsections 1, 2, and 3 that deliberately is used in the ordinary sense of the word and is not to be narrowly construed. So pausing there, that echoes what Judge Goodall had said. It's not a narrow construction, it's a wide construction that captures a lot of acts. And then in particular, the provisions of subsection 3 indicate that deliberately means after consideration of all the relevant facts. Then the point that I highlighted, Lord Justice Waller particularly agrees with that strand or element of the reasoning of Judge Goodall. On the sentence, in particular, the provisions of subsection 3 indicate that deliberately means after consideration of all the relevant facts. I understand it's common ground that what Lord Justice Waller was doing, seeking to summarise the effect to what was then section 17, subsection 3, now 1912. That's in the respondent supplemental skeleton argument, paragraph 6 at the end. So I think we agree what he was trying to do. Whether or not that was precisely accurate doesn't matter for the purposes of this appeal, because 1912 is not an issue. I don't need to develop that. Oh, for completeness, over the last page, page 47, Lord Justice Watkins agreed with both the judgments. So that's proposition 1. Deliberately governs the act or omission, not the consequence. Proposition 2, subsection 2 works by excluding an act or omission done in good faith while unaware of a relevant fact.
Sorry, can you say that again? I wasn't keeping
Sorry,
up.
it's also a bit of a mouthful. Subsection 2, 1912, works by excluding an act or omission done in good faith while unaware of a relevant fact. And I'm only providing this for context because if you're construing a word in 1911, the context may be of some significance. So in the supplementary list of authorities, tab 5, for those who have tabs, page 83. So this was an intentionally homeless case, slightly unusual. The homeless applicant left the unit left her accommodation without waiting for possession proceedings. She'd been told to go to the local authority, and if she'd done so, they would no doubt have advised her to stay there. So did she become homeless intentionally, either because she left or because she failed to go to the local authority for advice? The Court of Appeal held that she hadn't become homeless intentionally, and you can see the holding on page 83. Subsection 2 provided relief against the otherwise potentially harsh consequences of subsection 1 for those who acted in ignorance of a relevant fact, subject to the requirement of good faith. And good faith carried a connotation of impropriety or an element of misuse or abuse of the legislation. So one might say, looking at the matter broadly, the harshness of subsection 1 is relevant to the liberality of subsection 2. But all I'm really interested in is within the judgment of Lord Justice Lloyd, he conducted an analysis of previous decisions and of the legislation. So page 86, paragraph 6, second sentence.
Sorry, page
86 within the bundle.
Yes.
Paragraph 6, second sentence. Subsection 1 is in itself clear, simple, and absolute. Apart from the fact that the act for omission must be deliberate, nothing in it allows the state of mind of the person in question to be considered as to, for example, whether the consequence of homelessness was foreseen. Subsection 2 qualifies it in one respect by excluding an act or omission on the part of someone who was unaware of a relevant fact. Relevance must presumably be to the doing of the act or omission, but subject to the safeguard that the act or omission must have been in good faith. That's all I really need for my purposes. And on page 88, he quoted from a judgment of Lord Justice Sedley in a case called O'Connor. That's citation is page 87, paragraph 13, but I'm just interested in his Lord Justice Sedley's paragraph 30, which sets out the basic effect of 1912. So that's on page 88. If I just invite you to read them.
Yes.
The context. Then proposition 3, in order for the act or omission to be deliberate, the person must have a real choice. And within the original authorities bundle, page 48, tab 11, for those who have tabs, is the decision of the Court of Appeal in the Crown against Wandsworth London Borough Council, ex parte Hawthorne. The rent arrears case, page 50, the Lord Justice North sets out the expression of law. Whether a person evicted from qualifying accommodation for failing to pay rent, which she's unable to pay because of the inadequacy of her resources to cover both the rent and the maintenance of her children, fails to pay it deliberately within what have become section 61 in part 3 of the Housing Act 1985. And the facts were briefly, page 51, below letter E, one sees an interview note. Basically, the applicant was saying she couldn't afford to pay the rent because she needed the money to maintain her children. The father walked out, never contributed. And then we have a decision, opposite letter H, where this authority is satisfied your homelessness is intentional. You willfully and persistently failed to make payment of rent. As a result, you were evicted. Consequently, you ceased to occupy accommodation which would have been reasonable to continued occupation. And then a throwaway line, full consideration has been given to your reasons for non-payment of the rent, and these were taken into account when making the final decision. And then there's some correspondence. You see the quotation between letters B and C. The solicitor was saying she couldn't afford to pay the rent, and it wouldn't have been reasonable for her to continue an occupation. And that was given a somewhat dismissive reply between letters C and D. And then the High Court judge, in giving judgment, you see opposite letter F, he considered the question was whether the authority was bound to take into account the applicant's financial means. And if the answer was yes, it's manifest that the decision is fatally flawed. In essence, they hadn't really taken into account the means. And Lord Justice North makes that point between letters G and H. The submissions, the rival submissions that are set out are page 53. Above letter D, Mr. Straker submitted that a person does or fails to do something deliberately if he makes a considered choice between two courses of action or inaction, either of which he's able to take. Thus, if he makes a considered decision to apply the only money he has in his pocket in maintaining his children, instead of paying it to his landlord, he deliberately fails to pay the rent, and that was rejected. And then Lord Justice North goes on to make some statements about the purpose of the legislation. Particularly, admittedly, it's not part of that purpose. That's the purpose to house the homeless. To house those whose homelessness has been brought upon them by their own fault. But equally, it's no part of it to refuse housing to those whose homelessness has been brought upon them without fault on their part, for example, by disability, sickness, poverty, or even a simple inability to make ends meet. So the decision was, it's not deliberate if you don't have a real choice. And then there was some discussion about whether the inability to make ends meet would also be relevant to the reasonable to continue to occupy. No conclusion was expressed about that. I'll summarise it that way. Yes, so page 54, second sentence. Whether, as Mr. Carrot alternatively submitted, it can also have consequences under the reasonableness requirement is a question on which it's unnecessary to express a view in this case. So the judge at first instance was upheld. My proposition 4 is that in many cases there is no difference between the real choice test and the reasonable to continue to occupy test. And maybe my learned friend and I don't disagree about this very much, because in her supplemental skeleton argument, paragraph 6D, she agrees that there's a substantial overlap between the two tests. And just to explore that with your lordships and your lordship for a moment, so if you take a failure to pay rent case, the question is whether the applicant could afford to pay their rent without depriving themselves of the basic essentials. If the answer to that question is no, two consequences follow. One, their failure to pay the rent was not deliberate. And two, the accommodation would not have been reasonable for them to continue to occupy. And as an example of that, in the supplementary authorities bundle, Divider 6, page 94. Decision by the Supreme Court in 2019, Samuels and Birmingham City Council. Probably just invite you to read the head note. I mean,
Sorry, I just missed the page.
Sorry, yes, it's page 94, my lady. It's just a basic point. It's a Hawthorne case, but the case was argued, and the Supreme Court analysed it purely in terms of, was the accommodation reasonable to continue to occupy, the RCO issue.
She couldn't afford it.
She couldn't afford it, so it wasn't reasonable to continue to occupy. So my basic point is, in many cases, I mean, never say never. It's a bad thing for an applicant to say never. Then someone will come up with some extreme example where they might be different. But I am struggling to see any case where there is any difference between real choice and reasonable to continue to occupy. And in this case, the respondent's case was that the effect of continuing to live in the Brighton flat on his mental health would have been so bad, or was so bad, that he was forced out. So it wasn't a deliberate act in handing in his notice and leaving. Well, if the effect of continuing to live in the accommodation on his mental health would have been that bad, then it wasn't reasonable to continue to occupy.
What you've done there is quite significantly narrow the basis upon which it said his mental health caused him to decide to leave, haven't you? Because there are all sorts of reasons why mental health may cause you to make a decision which you wouldn't have made but for the mental health, which do not necessarily reflect the conclusion that the property is no longer reasonable to occupy.
That's ground one, which I'm going to address in a moment. Here I'm on real choice, in the sense that what real choice, the real choice test aims to grasp is a situation where you're forced to do the relevant act. Where you're talking about leaving accommodation, the question is whether the circumstances are such you're basically forced to leave. And my submission is, in that respect, there's no difference between being forced to leave and the accommodation being reasonable to continue to occupy. If it's reasonable to continue to occupy, then you're not forced to leave. Because it's reasonable, you stay.
I'm not at all sure that they are the same in the context of mental health, because somebody may be faced with a choice that can be said to be a real choice in terms of staying where they are, but their mental health deteriorating and they know that's going to happen. Now, that might still be a real choice, but it might not be reasonable to continue to occupy.
So I adopt my lady's submission, which is that reasonable to continue to occupy is a wider So such that we're not reasonable to continue occupy is a wider class than forced out.
Mm.
My point is that the RCO issue encompasses being forced out. I agree with you. I mean, it's debatable, I suppose. In a rent arrears case, I would say usually they're the same. In other words, if you've got enough money to meet your basic essentials and pay the rent, it's reasonable to continue to occupy, and it's regarded as a deliberate act not to pay. And they're pretty much the same thing. But it has crossed my mind in thinking about this case that the RCO issue is actually wider. So it's a more generous test for the applicant in this case than being forced out due to his mental health. I think I'm now getting a little bit closer to what my Lord Justice Zacaroli is interested in. Proposition 5, where the issue is whether an applicant is legally responsible for a contract or a contractual transaction he has entered into or not, the dividing line is the test of mental capacity. So my basic proposition is that it is the general law that a person is legally responsible for a contractual transaction they enter into unless they lack mental capacity. In essence, they don't have the ability to understand the nature of the transaction. And the reason why I can see my Lord may have some questions bubbling up.
Not yet.
Not yet.
Not yet.
So listen. The reason why I put it in this way is I think my learned friend makes a valid point. It's a fool's errand for me to try and produce a comprehensive list of every circumstance that might be not deliberate. I suppose you could do something by mistake. It's difficult. That doesn't really crop up much in intentional homelessness, but one could do something by mistake, fall over. That's not a deliberate act, that's an accident. You know, there might be duress, there might be undue influence. That might not be considered to be a deliberate act. Someone else really forced you into it, and so forth and so forth. Where one is considering the question, was the homeless applicant legally responsible for an act because of their mental impairment? My submission is the general law provides the answer, that the test is that of mental capacity. So that if a person lacks mental capacity to do an act, it won't be deliberate. And so we've provided some excerpts from Chitty on contracts on this in the supplementary bundle of authorities, tab 9, page 170. So the incapacity of one or more of the contracting parties may defeat an otherwise valid contract. Prima facie, however, the law presumes that everyone has a capacity to contract. And then skipping the next bit. In English law, 3 classes of individuals are subject to some degree of personal contractual incapacity: minors, persons lacking the requisite mental capacity, and drunken persons. Abnormal weakness of mind, short of such mental capacity as prevents a person from having the ability to understand the nature of the transaction, or immaturity of reason in one who has attained full age, or the mere absence of skill upon the subject of a particular contract, affords in itself no ground for relief at law. or inequity, but then it goes on to refer to undue influence and so forth. And then page 174 sets out the general test. But the first proposition, it depends on the nature of the transaction. What is required in relation to each particular matter or piece of business transacted is that the party in question should have the capacity to understand the general nature of what he's doing. And you see the quotation from the testamentary capacity case. I believe my Lord Justice Zacaroli is familiar with that area of the law, and I believe the leading case is Banks and Goodfellow on testamentary capacity. And we have provided one example of that principle at work in the context of intentional homelessness within the supplementary bundle of authorities at tab 3. Page 49, decision of the Court of Appeal, Lord Justice Dyson, Lord Justice Judge. It was a rent arrears case. Page 54 towards the bottom, your lordships and my lady can see that the homeless applicant relied on a report from a consultant psychiatrist. Because of my severely disturbed mental state, I could not have been capable of making such a decision. And then Lord Justice Dyson refers to Dr. Brown's report in some detail. Paragraph 16 probably suffices. I've considered the question of whether he may have made himself homeless intentionally, and in my opinion, because of his severely disturbed mental state, he would have been incapable of making such a decision. So the authority withdrew their previous decision and took that into account, produced a decision which is summarised paragraph 18 on page 56 within the authorities bundle, bottom of that page. Quotation from the review decision: having considered all the medical information available to me, Mr. Hijazi's actions around the April 2000, the information provided by Mr. Hijazi are interviews. In fact, Mr. Hijazi had the support of his wife, and in my view, a supportive landlord. I'm of the opinion that he was capable of managing his affairs and was fully aware of the consequences of not paying the rent. And paragraph 35 on page 62, there was a big debate about the fact that the review decision didn't refer expressly to the report of Dr. Brown, and whether or not a witness statement from the reviewing officer saying, I didn't refer to it, but I did take it into account, was admissible. You don't need to worry about that. Paragraph 35, Lord Justice Dyson decided the letter contains sufficient reasons for concluding the appellant was capable of managing his affairs during the relevant period and was not prevented from doing so by any of the medical conditions from which he was suffering. Simplify that. That's how, in my submission, it's understood this works. In other words, if a homeless applicant says, yes, I did the act, but it wasn't deliberate because of my mental health condition, the general understanding is, the test is that of mental capacity. And that is right, because that's the general law.
How does that tie in with the cases about non-payment of rent? where you can have something that is not deliberate because there's no real choice.
Yeah, that's different.
But in the context of mental health, you could have no real choice, but the person could perfectly well have capacity. So, I mean, suppose, for example, somebody was suicidal and their mental health practitioner said, if you remain in that property, I am seriously concerned about you.
Yes.
Well, they would be exercising capacity and deciding to leave.
I agree. I agree with that. So that's the forced out part, as it were. Here we're on, could they make, are they legally responsible for the act at all because of their mental health?
So it's another, not a substitute.
No, it's
for
a
the
different.
no real choice. It's
Yes,
another aspect.
I agree with that. It's significant. Well, it's relevant because in this case, the respondent rode all three horses. As you'll see, it was submitted on his behalf. The accommodation wasn't reasonable to continue to occupy. He had no real choice, was forced out, basically for the same reasons, and also that he lacked capacity to make the decision to serve the notice to terminate.
You are equating, are you, the question whether someone was caused to decide to leave because of mental ill health? You're equating that with the test for mental capacity to enter into a contract.
Well, the way your lordship puts the question is reflects how my learned friend puts her submission on the meaning of deliberately. My submission is, if a person suffers from mental illness but doesn't act, and the argument is, I'm not legally responsible for that act, the test is mental incapacity, and the same thing applies to deliberately.
Well, hang on a minute. Clearly, if the argument is, I did not have legal responsibility for the act, then it rather sounds like that's just repeating the test for mental capacity.
But I didn't do it deliberately.
Well, but that's a different point. If I didn't do it deliberately because I was caused to make the decision due to my mental illness, for example, I was so depressed and the depression was caused by the environment I was in, that may not amount to a lack of mental capacity, but you can see how the mental illness is causative of the decision.
Well, you're now bringing me on to my proposition 6, which is answering my learned friend's case.
Right, but I'm just trying to understand your case.
Yes.
Are you equating the question of a deliberate decision that it's argued was caused by mental illness? You're equating that test with the test for mental capacity and the ability to enter into contracts.
In essence, I'm equating, I say that the relevant question is not whether the decision was caused by the mental illness. And that that's what I was going to address you on right now.
And just before you do, would it be fair to say that the way you're putting the case is quite a long way from the guidance? Now, you've taken us to authority as to potentially the limited effect of guidance. It is the case, isn't it, that the statute tells local authorities to have regard to the guidance,
Yes.
and the guidance doesn't really fit how you're putting the case.
So that's original authorities, page 328. Well, so it's 917. B and C on that page. I mean, it's put in terms of the housing authority has reason to believe the applicant is incapable of managing their affairs. Well, let's see how it can be reason to believe. They've got to be either satisfied they have capacity or not.
I mean, well, two things. A, C is not expressed in quite the terms you're expressing it.
Limited mental capacity. Temporary aberrations caused by mental illness.
Yes. Now, is a temporary aberration caused by mental illness equating it with lack of mental capacity?
Temporary lack of mental capacity is what I'd say. It's really driving it.
And then 9.16 might be said to put it more generally. An act or omission should not generally be treated as deliberate, even where deliberately carried out, if it is forced upon the applicant.
Yeah,
through
that's a
enforced error.
separate point
Yes, I see.
in my submission. So this tends to, gives advice on a variety of circumstances.
It certainly doesn't say apply the mental capacity test that.
Well, what does 9.17b really mean?
Well, if a temporary aberration caused by mental illness really meant lack of mental capacity, it would say so.
My submission is that in terms of the general law, what the dividing line for deliberately, and this applies generally, obviously we're a specific context, but one can think of all kinds of contexts, civil contempt, criminal law, etc., and they all have slight variations. Here we're talking about whether someone deliberately entered into a contractual transaction. My submission is that it is at least a relevant part of the context for construing deliberately as it applies to that. The general law says the dividing line is mental capacity. Did you understand did you have the ability to understand the nature of the transaction?
And just comparing the guidance, and you've pointed out the recent Supreme Court view on statutory guidance, that allows in 9.17c for a temporary aberration caused by frailty. Is that the same as lack of mental capacity?
It seems to put the bar a bit lower.
Yeah,
I accept that. It's rather like when we were reading from Chitty, there was a statement that said the weakness of mind not amounting to mental incapacity doesn't relieve someone from legal responsibility for a contract, basically.
Yes.
And this guidance suggests that the bar is here, in terms of an act not being deliberate, is a bit lower.
Yes.
Yeah, but the whole of the second part of C puts the bar lower. Well, in fact, the whole of C, because limited mental capacity is not the
Limited
same
mental
as
capacity is expressly a lower bar.
under the Mental Capacity Act. It's quite hard actually to have lack of capacity. Most people retain mental capacity.
It's for you to decide whether that guidance is the same as the meaning of the word deliberately. I mean, you can't construe this literally. It's my first suspicion. Say if the local housing authority have reason to believe, that's just contrary to the statutory scheme. They have to be satisfied whether or not an act is done deliberately. So reason to believe has got nothing to do with it. That's obviously not in accordance with the statute. Then we've got C, limited mental capacity, temporary aberration. I mean, I totally accept in terms of general law, if one has a temporary aberration of mind so that you lack capacity for a short period of time, that means you're not legally responsible. It's not deliberate in terms of the general law. Whether or not, as it were, paragraph C is driving at that there is mental capacity, but it's not full capacity. It's not what one would expect of an ordinary healthy individual. I would say you can't derive that from the word deliberately. Deliberately, as the authorities indicate, is quite a clear, quite a harsh text. It basically means intentional. So that in terms of the general law,
Because quite often we have to assess things that are deliberate but not intentional. And of course, The act here concerns not intentionally becoming homeless.
Yes, deliberately is the statutory word. I entirely accept that. But in terms of the causation point, which is the way that my Lord Justice Zacaroli put it back to me, I'm going to ask your indulgence in advance because this is it's going to sound like a philosopher's thought experiment. But I just wanted to make the general point that the word deliberately is concerned with legal responsibility, not causation. And I'm just going to give you a philosopher's thought experiment to illustrate that. So if a tenant hands back his keys after reading a newspaper article describing the local area as going to the dogs and influenced by that article, both the publication of the newspaper article and his decision to leave are causative of the act of handing back the keys. But there is no doubt that under whatever test you might wish to apply, it was a deliberate act or an act for which he was legally responsible. And that's why I say this, the way that my own friend puts the case, which is in life, causation, factual causation is complex. Well, I totally agree with that. That's not relevant. The word deliberately is a word which relates to legal responsibility. As Lord Justice North put it, is it their fault? And it's no less someone's fault if they hand the keys back, having been influenced by the newspaper article. In my submission, that's a clear and obvious kind of case, but just to make the point that legal responsibility is not about causation. If a person suffers from mild depression, and that is one of the factors that influences them to hand back their keys, in my submission, that act is still a deliberate act. Because the law regards them as legally responsible for that act, provided they had mental capacity. Even if there is a lower threshold under the Housing Act 1996, in accordance with 917C of the Code of Guidance, in a case of mild depression, the answer is the same. That may have had a causative effect, but the law regards that act as being the result of the exercise of freedom of choice. And I don't want to get too jurisprudential about all this, but in terms of legal responsibility, there is a value judgment, and part of that value judgment is the importance that society places on individual autonomy. I did provide in the skeleton a reference to Mental Capacity Act case law about this. But the general point is that just because a person suffers from a mental disability doesn't mean they can't make choices for themselves. It's a general point about personal autonomy. That has a plus side in terms of the Mental Capacity Act, which means that, you know, they shouldn't be deprived of their liberty, or, you know, whatever it is, or decisions should be made for them by someone else, by a deputy appointed by the Court of Protection, if just because they have a mental incapacity. The question is whether they're capable of making a decision for themselves. It has a negative side, which is they, if you like, that they are regarded as legally responsible for acts which they do. although they have a mental disability, if it's one that does not remove their mental capacity. That's where the law draws the line, and it is value laden. So you're construing, task for you is to construe the word deliberately, and in this case to ask yourselves how mental illness interreacts with the test of deliberately in terms of the individual's ability to make that decision. My own friend's case is that if the mental illness has a significant influence on the decision, that's game over, it's not deliberate. And I say that's wrong in principle. Firstly, because of the general law and the value it places on personal autonomy. The law regards a person's act as being the result of the exercise of their choice unless they fall below the mental capacity threshold. But secondly, I rely on the purpose of the act. Lord Lowry. So if the test is that the act or omission was influenced to some degree by a mental disability, then every tenant who handed back their keys or failed to pay their rent while mildly depressed will be able to claim that that was not a deliberate act. And in my submission, that would undermine the purpose of the intentionally homeless provisions. And in saying that they would be able to claim that, I'm not saying that in a pejorative way. I mean, the statistics, I think, are quite well known about the prevalence of mental ill health in our society. They're astronomical. And I'm not denying that in many cases, if someone handed back their keys or failed to pay their rent, that mental ill health might probably, in many cases, plays a role. But in the context of this legislation, if you were to decide that's enough to conclude that an act or omission is not done deliberately, in my submission, that would quite fatally undermine the purpose of the legislation. So those are my submissions on the kind of interesting point, which is, you know, the case, the legal case in my learned friend's respondent's notice. I should probably stop and ask whether you've got any questions for me, and before I go on and do the more, you know, the harder stuff of going through all the facts and the, you know, kind of rambling decision which eventually gets there.
I suspect we will ask our questions. We probably better turn to the facts.
Yes, thank you. Right, so this, you know, imagine this was a decision about testamentary capacity or something, and we were appealing to your ladyship. And I think I'd start by looking at the basic facts, and then I'd look at what the judge found, and it's kind of the same exercise here. So I'm going to be referring to the supplementary bundles. Got contemporaneous documents. The issue being the respondent's mental state on the 12th of January 2016. Here we have a letter from a doctor, 23rd of June 2015. I apologise if you've already read these. I'll probably have to...
I mean, I should say, I think you probably have all looked at them.
Have you? Yeah.
So I'm not suggesting we shouldn't be taken to them because it's of crucial importance. I've also got in mind time is passing. So you can probably focus on the bits that matter rather than rehearsing everything.
Okay, I'm going to flip through these.
Yeah.
So you see here, this is the contemporaneous. This is what, just over 6 and a bit months before the notice terminate. So you can see what the doctor was saying.
So this is page 4, sorry.
Page 5 I was on.
Page 5 you're on.
Yeah, there is a previous one.
Don't worry. Yes.
Yeah, the previous one was about physical conditions. This
Yes.
is about mental health. Yep. Last paragraph of the previous one. Right, so, I see. My learned friend making a point about the previous page, page 4. So this is about the respondent in his Islington accommodation. Is that right?
I'm sorry to interrupt. I just wanted
You've got in mind the long history of recurrent depression.
That's all I wanted
Yeah.
to draw the
Yeah.
court's and
Current-
Mr. Hutchins' attention.
Current depression. And then we have that also on the next page, page 5. Current depression, anxiety, some obsessive compulsive traits, intermittent bouts of depression, the overdose in 1998. He overeats and sleeps a lot, lacks motivation, feels permanently tired at these times, occasional suicidal thoughts. And then claustrophobia and panic at times, for which he has occasionally been prescribed diazepam. When anxious, he feels he needs to repeatedly check things. It affects his relationships and his concentration and impact on all aspects of life. That's his GP, Dr. Patel. And then page 6, we have after he's completed his mutual exchange at the end of November 2015. And then the second paragraph towards the right-hand side. Unfortunately, having made the exchange, he now feels it was the completely wrong decision. Does not think he can settle in Brighton. He's desperately keen to move back to London, where his family and friends are. And then it kind of repeats the diagnosis of recurrent depression and anxiety, intermittent bouts of depression for many years, and has even taken an overdose. Claustrophobia and panic at times. When anxious, he feels he needs to repeatedly check things. He's quite vulnerable. I fear the move to Brighton would seem to have already caused him heightened anxiety and some depression. I do feel he'd be much better off staying in London close to family and friends. So that's what the GP was writing in December 2015. That's quite contemporaneous. We don't need to worry about the next one about. Then we have the email, page 8, email 31st of December 2015. So this was an email written to the Guinness Partnership, which was his landlord, while he was away on holiday, about his 2 bank cards having been stolen. And it says £300 of mine was spent on pizza delivery and Argos possessions. The thieving culprit then spent another £539 with online shopping, and then had the disgusting audacity to then use my other new card for another £500, which could only have been stolen from my communal post box, which is locked. They must have pulled it out if the postman left a bit out. I never would have done this mutual exchange if I'd known there were criminals living in the block, or if not a resident, then it's their guests or friends. Got faith in the post office services. I would like an exchange ASAP, please. So that's what he was saying. But then we have some bank statements starting page 9. We have a Flex on that page, Flex Plus account sent to the Brighton flat. The statement sent to the Brighton flat. There's nothing suspicious on that account. But then page 10, someone's written CO. My understanding is that when the respondent learned of the suspicious, well, the thefts from his account, he arranged for his bank statements to be sent to his sister in Plymouth. Yeah, that's right. So the solicitor's written CO.
I mean, the review decision obviously attaches significance to these.
Yes.
We probably don't need to worry too much about the detail, do we? They show Mr.
Context. Well, it shows he was in
Bussandra travelling
Liverpool,
around.
Amsterdam, Vienna, Salzburg, Frankfurt, Cologne, Luxembourg, Brussels, then Wakefield, Hull, Victoria, Portsmouth. That's briefly his
Yes.
tour. In terms of the actual suspicious transactions,
We don't need to look at those, do we? I mean, they're not.
really. It's because the reviewer accepted
Yes.
some money was stolen out of his account. And then he made a crime report, page 14 onwards. And I think the point about the emails with the Guinness partnership begin on page 17, page 18, turning it sideways, landscape at the bottom, 8th of January. You can read what that says. He advised that over the Christmas period he had property stolen, which he reported to police. Wishes to move back to London. His question is if we can move him now. I advise we do not have anything vacant. So he advised he will hand his notice in. And then the notice to terminate is pages 19 and 20. Background points. It's a simple transaction. Appears to be a coherent, rationally completed document. We don't really need to go into the detail, but it sets out also his reason. Bottom of page 19, I've had to leave my home due to antisocial behaviour and stealing of all my post, bank cards, money from other tenants within the block. Exclamation mark. So it appears to be a rational document. Page 21, this is the first reference to the use of the word harassment, I think. Second paragraph. A bit later. So Mr. Bussandra is now homeless, and this has aggravated his depression and anxiety further. He's felt increasingly suicidal. So urgently to the Islington crisis team on the 27th of February 2017. And he's vulnerable. That's probably the main purpose of that letter, to assist with housing application.
I'm sorry, the housing application was made in 2020. The letter is 3 years earlier. Whether or not there was something else, I don't know, but it's certainly not this application.
Yeah, it's not this application, but it reads like a letter that was written in support of an application. So we then have at page 28 all the way through to page 46, a very detailed report by Dr. Wahid, a consultant psychiatrist. And one sees the diagnoses on page 38 in bold. depressive disorder, current episode moderate, and post-traumatic stress disorder with the diagnostic criteria referred to, and that there are then detailed opinions about his mental state and their effect. So 39, 414, current mental state fulfills the criteria for moderate depressive episode in 2022. 415D, reduced concentration and attention. 421, intense or prolonged psychological distress of exposure to internal or external cues that symbolize or resemble an aspect of the traumatic events, which I understand is his traumatic childhood. Then so on page 4432, the disturbance causes clinically significant distress or impairment in social, occupational, or other important areas of functioning. Yes, in my opinion. And over the page 41, you see at 436, 438, some detailed answers about that. 448, 449. Current depression and PTSD associated impairment has an adverse effect on the ability to carry out day-to-day activities. Probably this was obtained largely because the appellant's initial response was you don't have a priority need, and so this was submitted to support we agree. It looks very much like a report which addresses priority need, particularly it's where it's talking about ability to carry out day-to-day activities that would be relevant to vulnerability.
Yes.
So there's a review decision, an appeal, withdrawing the review, withdrawing the original decision. Where we pick it up really is divider 19 for those who have dividers, page 51. This is where, in answer to questions from the City of London, the respondents' solicitors, GT Stewart, answer a number of questions, and they set out his factual case, really for the first time. And they say he left his accommodation due to ongoing abuse and harassment from his neighbours, which included theft and use of his bank cards, antisocial behaviour and homophobic abuse. Our client reported the incident to the police. Brighton and Hove District Council, no action taken. They said there was a lack of evidence and the harassment continued. And our client reported the incidents to the police. Brighton and Hove District Council, no substantive action taken. Harassment continued. The abuse and harassment was having a severe impact on our client's mental and physical health, as a result of which he felt he had no choice but to leave. So that was his factual case, the first time it was really set out. And then, in response to it, there have been numerous minded to letters in this case, so there's no point taking about fairness. So this is one of the letters from GT Stewart containing representations. It's dated the 9th of January 2023. It begins at page 59. And your lordships and your ladyship see page 60, the general nature of his case. Our client was subject to criminal offences, antisocial behaviour and homophobic harassment while resident of the property, which had a severe impact on his mental and physical health. For this reason, it was not reasonable for our client to continue to occupy the accommodation. So, in a sense, echoing the exchange between myself and my lady earlier on, Here it's being put on the basis of reasonable to continue to occupy.
Actually, if you just stay there,
Yeah.
if you go further down the page, this is your point again, I suppose. Section 1911 is quoted, and then it says, as determined above, the accommodation was not reasonable for our client to continue to occupy. He therefore does not meet the definition of intentionally homeless.
Eagle eyes, yes. As we'll see, the way it kind of develops, they put it all three ways that it's possible to put it. No capacity, no choice, not reasonable. So page 65, there is the real choice. Point is made on page 65. This is relevant to our client's case. His mental health was suffering so significantly as a result of the ongoing abuse.
Sorry,
harassment-
where are you reading from?
Sorry, so above the lower hole punch, paragraph above the lower hole punch.
Yes.
This is relevant to our client's case. Not a viable option. There's another way of putting the same point. And then conclusion, our client does not meet the definition of intentionally homeless. And what I've underlined is due to the impact of the situation on our client's health, he could not remain at the property. He therefore lacked viable choices, had no option but to leave, didn't commit a deliberate act. And finally, it wasn't reasonable to continue to occupy. So it's put both ways. At that stage, they're not saying mental incapacity. So then we have the section 184 decision, which is in the core bundle, pages 179 to 186. I don't think I need to go there, just for your reference. But the only point I picked up in the skeleton is that the original decision maker rejected his factual case that he left the Brighton flat to escape from abuse and harassment, and stated in her view there was a pattern of his reporting unsubstantiated allegations of antisocial behaviour in attempts to access alternative housing or services. So not the review decision stands or falls on its own merits, but the only point I'm making is there's no issue about fairness here. This was squarely put. So there was a request for review, and the detailed representations in support of the review begin 8th of June 2023, page 67, tab 21. So we've got page 67 under the heading Evidence from the Property. As stated in previous correspondence, the property was unreasonable to continue to occupy because our client experienced theft, antisocial behaviour and homophobic harassment while living there. And then page 75 refers to his mental health, concluding below the lower hole punch, therefore it is submitted in addition to the above, when the theft and other incidents occurred, the property was also unreasonable to continue to occupy due to the effect on our client and his mental health. His conditions are likely to be seriously affected by incidents such as antisocial behaviour, theft and homophobic abuse. Further, our client's condition was worsening before the theft happened.
At this stage, mental health comes in a different way.
Well, it's
The
always
point is that there is an effect on mental health rather than that mental health compelled the decision.
Yes. Yes, at this stage, it's either not deliberate because he was forced out, no real choice, or not reasonable to continue to occupy. And you've heard my submissions on that, it's basically the same thing. and that's reflected by the representation. So page 77, not reasonable to continue to occupy. This is because he suffered from incidents. Sorry, I didn't tell you this. Again, it's just above the lower whole punch. It is submitted that paragraph. This is because he suffered from incidents in the property that worsened his depression and made him feel an overwhelming need to escape from the property. Our client felt so distressed by the incidents he had experienced that he had to urgently leave the property. In that context, it was not reasonable for our client to wait potentially years for mutual exchange to be arranged. This is the letter where they raise capacity, page 79.
And perhaps it's worth just noticing the public sector equality duty.
Yes, yes, it's invoked. In terms of the general requirements of the PSED. So when they, rather like the appeal, all that's really said, page 79, as our client is disabled, it recites the requirements, but it doesn't say how they've been breached, other than recite it, you know, it's cut and paste from a judgment, more or less. And then immediately after, it's unreasonable. So, if you comply with the PSED, it's unreasonable to continue to occupy. And then a new heading: act was not deliberate. Quoting from the section of the Code of Guidance that I was asked a number of questions about, 917, subparagraph C. And then referring to the medical evidence, Dr. Wahid and Dr. Patel, we've seen our client instructs that during episodes of depression, he does not think or act rationally. His mind is so messed up that he cannot make decisions. And that he had an overwhelming feeling of wanting to escape from the property. Temporary aberration, and therefore not deliberate. And then, for good measure, its real choice point is made again on page 80. So by this stage, it's put all three ways. And what the important development thereafter is that a number of letters were obtained from Laura Pisaneski, who is an advanced clinical practitioner. And you'll obviously have to look at these quite closely. The initial letter, 10th of July 2023, having set out recorded his diagnoses and describing final paragraph 95, the effects on his daily life. Over the page, due to his mental health conditions, this can at times affect his judgment and decision making. Then the second paragraph that begins on page 96, although I did not know Mr. Bussandra in 2015-16, based on the knowledge I have of his mental health conditions, including collateral information both from Mr. Bussandra and other services involved at the time, Mr. Bussandra's mental health conditions are likely to be similar in nature in 2015-16. Although we might interpolate that he's had a period of rough sleeping, street homelessness intervening. But in terms of Mr. Bussandra's decision to leave the property in Brighton, Mr. Bussandra reported that he was experiencing homophobic abuse from neighbours in addition to bank card theft, Mr. Bussandra is likely to be experiencing a major depressive episode, and due to this, he wanted to escape the situation. He may not have been able to rationalise and think clearly. Due to his diagnosis of PTSD, it's likely he was feeling unsafe and feeling intimidated and vulnerable. So the simple point, which is a thread which runs through all of the letters from Ms. Bussandra, is that her opinion was based on what Mr. Bussandra told her. We'll look at it in a little bit of detail because we really have to, but it's all based on Mr. Bussandra's similar statements. Mr. Bussandra reported that he was experiencing homophobic abuse from neighbours in addition to bank card theft, and that he's likely to have been experiencing a major depressive episode. And due to this, he may not have been able to rationalise and think clearly.
And it's certainly worth noting that phrase, because obviously that phrase features later on.
Indeed, indeed. So there was then a review decision, an appeal, review, a decision withdrawn, and then there were further details in a letter of the 24th of October 2023, which begins at page 111. And this puts forward his case quite eloquently. The paragraph that I picked up is at the bottom of page 112, top of page 113. So this is the final straw of submission. So the case that was being put is he's got recurring depression and anxiety, PTSD with some obsessive compulsive traits. He suffers from antisocial behaviour, homophobic abuse, and the theft of his bank cards is the last straw that pushes him over the edge to being in a state where he can't think rationally. And they enclosed the preceding letter, 17th of October 2023, page 106. Which Ms. Bussandra says in the second paragraph was to clarify the previous letter of the 10th of July. Page 107, directly level with the lower hole punch, a point I'm sure my own friend will place some reliance on. This additional letter has been written on the assumptions no antisocial behaviour occurred, that Mr. Bussandra only experienced the theft of a bank card in late December 2015, resulting in transactions that were refunded. And then 108, middle of the page, you'll have to read all this quite carefully, but she summarises the previous letter. So likely to be similar. Then she's been provided with documentation by the City Council, sorry, the City of London, but then says, although I've reviewed the
Well,
additional documents.
I mean, there's a debate which I take it is no longer relevant as to other documents that have come in here. There's the letter seemingly from Dr. McIntyre, or something from Dr. McIntyre.
2010.
And there's the material from Dr. Blow and Dr. Macklin, or Dr. Falkowski. And at one stage there was sort of debate about why you hadn't seen those documents, but that's fallen away.
Yes.
Yeah.
So what she says in the paragraph level with the lower hole punch, although I've reviewed the additional documents that I've now been provided, I still conclude, based on Mr. Bussandra's recollection of his mood and mental health at the time, and how vulnerable and isolated he reported feeling, he was likely to be experiencing a depressive episode at the time. It carries on, refers to the historical assessment and her own assessment. Mr. Bussandra was likely to have been adversely affected by his difficulties with his accommodation and his thoughts and belief about antisocial behaviour having occurred, which would have adversely affected his mood to a greater degree than for another individual.
That sounds like a priority need point.
Well, the way my learned friend puts her case, that means it's not deliberate. Because where this is all going is that even if it was only his bank cards, he was more anxious than an ordinary person, which, as your lordship says, is kind of like vulnerability. And therefore, that must have had a causative influence on his decision to leave. But my answer to that is the one I gave previously. In law, one's regarded as responsible for one's own decisions if one has capacity. It's still deliberate. So we've got 108 bottom is quite important. Although this letter is written based on no antisocial behaviour occurring, Mr. Bussandra is adamant that he was feeling vulnerable and isolated, and he was experiencing what he describes as homophobic abuse from neighbours in addition to bank card theft. And so one then looks back up to the paragraph level to the lower hole punch. Mr. Bussandra was likely to be adversely affected by his difficulties with his accommodation and his thoughts and belief about antisocial behaviour having occurred. And then, so the final paragraph makes it explicit that this is based on a patient narrative, which is that, which we saw from the first letter, the 10th of July letter, that he was feeling unsafe, vulnerable, isolated due to homophobic abuse. And then over the page 109, I'm not able to comment on if he was experiencing a major depressive episode compared to a moderate or mild depressive episode. As stated in my letter from the 10th of July, I did not know Mr. Bussandra at the time. However, based on the information from Mr. Bussandra, so reading that all together, that means his narrative about what happened and how he felt about it, and the medical assessments prior to 2015, it is likely that he had been experiencing a major depressive episode. Due to this, and based on the conversations with Mr. Bussandra, he would have wanted to escape the situation, and he may not have been able to rationalise and think clearly. So, I think you've got the general point, which is, although as a matter of form, it's an opinion based on the assumption that there was only the theft of the bank cards, no harassment, homophobic abuse. In substance, it's also dependent on that narrative, because Mr. Bussandra's recollection of his mental state, on which Ms. Pisanesky relies heavily, is bound up with that factual issue. We then have yet more exchange. So we have a Regulation 7, minded to decision, begins at page 118. And this includes, in particular, paragraph 13, pages 121 to 122, which provide the context for the final letter from Mr. Pisanesky.
So should we read that paragraph?
I think probably yes.
Paragraph
13,
13.
my lord. Begins at the bottom of page 121. I think I pointed out in my skeleton that G.T. Stewart asked at the beginning that inquiries go through them, and that is the way it carried on. But as it were, this is the written equivalent of an interview where Mr. Perdios puts to Mr. Bussandra, Mr. Pisanesky stated you must have been feeling unsafe and feeling intimidated and vulnerable, but your bank statements show you doing all the things that an ordinary person can be expected to do. So it's the equivalent of it being put to him. You've told Mr. Pisanesky that that's how you were feeling, but I'm putting to you that actually, when you look at your bank statements, you were doing a lot of ordinary things which are inconsistent with your description of how you were feeling. And then we get the final salvo, page 133, where Ms. Pisanesky sticks to her view. You can see on page 133, in response to the minded to decision, lower whole punch, I've reviewed the bank statements and spoken to Mr. Bussandra regarding his trip abroad, etc. Having reviewed the bank statements, spoken to Mr. Bussandra, I've not changed my conclusion. Mr. Bussandra confirmed that he was suffering from a depressive episode, and as a result of this, he wanted to leave and didn't feel safe in his current location. So that may be sounds a little bit self-diagnosis, but it may be a compendious way of saying that he stuck to his account that when he went on his European holiday, he did so because he didn't feel safe in his flat. And just to jump ahead, of course, what the reviewing officer decided was, prior to the theft of the bank cards, no antisocial behaviour, homophobic abuse took place. So there was simply nothing that had happened to make him feel unsafe. And then one can do a more detailed analysis on the letter, but she sticks to her view, likely to be experiencing a major depressive episode. Due to this, would have wanted to escape, and he may not have been able to rationalise and think clearly. Right at the bottom, 133, Mr. Bussandra has explained that these decisions to travel were made in response to the depressive episode that he was experiencing at the time. And then over the page 133, although I've reviewed the bank statements, this does not change my view. After also speaking with Mr. Bussandra, and the point I make about this is there are numerous references to being based on his account. Mr. Bussandra's recollection of his mood and his mental health at the time, how vulnerable and isolated he reported feeling. He was likely to be experiencing a depressive episode at the time. And then it goes on, his thoughts and belief about antisocial behaviour having occurred, specifically referred to, this would have adversely affected his mood to a greater degree than for another individual. And then concludes, for this reason, Mr. Bussandra has explained that he was not travelling away on holiday, but trying to escape, that his mental health at the time would have affected his judgment and decision making. So,
just one thing.
yeah.
I think I must be misremembering. At 133, Ms. Pisleski still expresses herself in terms of may not have been able to rationalise and think
Yes.
clearly. I had in mind that was firmed up somewhere. Am I misremembering?
There's a likely. So I think likely major depressive episode may have affected his ability to think rationally. That's, I think I'm right, and my learned friend will correct me if I'm wrong about that.
Yeah.
So in a sense, the question, what did the reviewer make of all this? And ultimately, it's for you to decide, was his decision a lawful decision or not? So that's in the core Bible. Page 164. It's a long document you'll have to look at carefully. What I've tried to do in my skeleton, paragraphs 47 to 59, it's kind of give an overview of its structure and basic findings. But if we go to the cold face, you can see it's a 15-page document. Begins on page 164. Page 165 to 166, we've got a huge list of everything he's looked at, which it's not suggested he was making any of that up. It looks quite credible. He did look at it all. We've got page 167, ability to make a heading, ability to make decisions. We've got page 171. Really, it's so reasonable to continue to occupy. Subheading 172, neighbours. Subheading 174, medical conditions, and the overall conclusions and the kind of nuts and bolts of a homelessness decision. So, page 16. So, the general point of this is there something frustrating about this administrative decision. It tends to weave in and out of the issues, and the actual findings on relevant questions are kind of scattered around a bit. But in terms of this particular case, it's self-evident that there is an overlap between the three ways in which it was put that Mr. Bussandra's mental health was relevant. In other words, not deliberate, no real choice, not reasonable to continue to occupy. And there was an interrelationship between the factual questions, what harassment or abuse took place, and how bad was the effect on his mental health. So my basic submission is you have to read it as a whole in order to correctly interpret its overall findings and the basis for the decision that was made. So one sees on page 167, paragraph 9 refers to the representation. Paragraph 10 summarises that. You stated you gave up your accommodation, so you've been subject to antisocial behaviour from your neighbours, theft of your bank cards, homophobic abuse and threatening behaviour. And it accepts theft of the bank card. And that he strongly believes that his bank card was taken by one of his neighbours. And that accepts, that's understandable. Goes on to say, believing that it was one of your neighbours or their visitors would have had an impact on you, including increasing your anxiety. It suggested this caused you not to be able to make rational decisions at that time. You also, just to interpolate a moment, this isn't a decision where he's just gone all one way. It's quite nuanced. He accepts that some of the problems with the presumed neighbours, or possibly not, but some of the incidents happened, but not others. He accepts that had an effect on his mental health, but not as great as claimed. So, you know, it is a nuanced decision. And then it goes on, final sentence, paragraph 10. You also stated that you suffered homophobic abuse and threatening behaviour from people in your building, suggesting that this had a further impact on your mental health and ability to make rational decisions. Then sets out the test that for me to consider the nature of your medical problems and or any disability and assess how these impact on you, and consider whether your decision to leave your accommodation was deliberate, or if it was a result of an inability to manage your own affairs, mental illness, or temporary aberrations. So I say, in this decision, he's, on any view of the matter, he's addressing the correct test. Even if the more generous, as it were, code of guidance test is right, that's what he's applying. In terms of, was it not deliberate because of either lack of or limited mental capacity? Paragraph 12. Before I do so, it is important to highlight. And then he says there's been no confirmation that the theft of the bank card was carried out by neighbours or visitors. There is also no information from the Guinness Partnership, who were your landlord, or the police, that you reported homophobic abuse or threatening behaviour to them. What that doesn't include is saying, for the reasons I will give subsequently, I reject your case that any of that happened. But that is set out below. If you skip forward to paragraph 32, so a few lines up from the upper hole punch, in the middle of the page, I am satisfied on the balance of probabilities you did not receive any verbal or other abuse or threats from your neighbours. So he did make that finding, and this rather reads as if that's assumed here. So Mr. Pedius goes on, whilst it's been suggested the theft of your bank card and alleged behaviour of others in the building led to you to give up your accommodation, the reality is you wanted to leave the property prior to the theft of your bank card, which occurred towards the end of December 2015. And it refers to Dr. Patel's letter of the 7th of December 2015. And then paragraph 13, I would suggest, shows quite a sharp focus on the respondent's medical conditions. And also expressly quotes from, importantly, Ms. Pisanesky's letter of the 17th of October 2023. It goes on, paragraph 14, I'm not disputing that you suffer from mental health issues. This clearly has an impact on you, on your day-to-day activities. Pausing there. This is a sharp focus on the effects of the mental conditions. But I'm not satisfied, this is to the extent that you're unable to rationalise and think clearly. I certainly do not agree with Mr. Pisaneschi that you were suffering from a major depressive episode and were unable to rationalise and think clearly in December 2015, January 2016. Now, just pick up my Lord's point, he's kind of taking a bit on the chin here. Now, your Lordship's point is quite right, but what she actually said was likely major depressive episode may have been unable to rationalise and think clearly. He's kind of taking it on the chin and just assuming she went all the way, and he's disagreeing, if that's what she's saying, he's disagreeing with her. And then he goes through the evidence, because it'll be recalled that one of the points that Ms. Pisaneschi made was that, well, let's look, he's performing a similar exercise. Let's look at the other reports we've got, and in particular the clinical psychologist. Of course, that's highly relevant. So he analyses that report for February 2022, which we looked at. And just to highlight, at the bottom of that page, it's not the same as saying they were a result of an inability to manage your own affairs, mental illness or temporary aberrations caused by mental illness, frailty or substance misuse. So he's there quoting the Code of Guidance, paragraph C, the one that we had a discussion about. And he makes the point that the diagnosis as at February 2022 was that the respondent was suffering from a moderate depressive episode, and the symptoms reported did not include you being unable to make rational decisions. Point we'll come on to, but it's obvious in this jurisdiction, the question is not whether you agree with his assessment of those that medical evidence, but whether it was a rational assessment. And then paragraph 16, he refers to the letters from Dr. Cattell. And the judge made something of this. So you will recall that Dr. Cattell said that on occasion he suffered from claustrophobia and panic. Then Mr. Perdius goes on, the evidence in front of me does not support this. And then he goes on to refer to what the bank statements show. So what he's deciding is that I'm not satisfied that at the relevant time you were suffering from claustrophobia and panic. That's not actually inconsistent with the letter. Again, he's rather taking it on the chin. Let's look at that at its highest. It might suggest that you were actually suffering from claustrophobia and panic in 2015. In actual fact, it doesn't say that. It says he suffers from that at times. But in any event, he analyses the evidence from the bank statements and the European tour. He goes on saying, Ms. Pisaneschi stated that you must have been feeling unsafe and feeling intimidated and vulnerable, but your bank statements showing you doing most, if not all, of the things that an ordinary person can be expected to do. So, just observation, it's perfectly legitimate for someone carrying out a mental capacity assessment to look at what someone does. And he also makes the point that Dr. Cattell didn't diagnose a major depressive episode on 7th of December 2015. And then there's some further detail, paragraph 18, about Mr. Perdios' interpretation of the bank statement. Shows shopping, paying bills, you're managing 2 bank accounts, you changed your address with your bank to your sister's address once you discovered your card had been stolen. These are the actions of a person thinking clearly and rationally. Travelling to several European countries requires a degree of mental capacity, and I do not accept that someone suffering from a major depressive episode and being unable to rationalise and think clearly would be able to do this, even if they do receive some assistance from family to travel abroad. paragraph 19, he's excluding perceptual abnormalities. Paragraph 20, he refers to the point about, I accept the theft, and he accepts it would have caused him stress and anxiety. However, the evidence in front of me does not lead me to conclude that this caused you to have significant mental health issues that meant you did not have the ability to make rational decisions. And he goes on to give some more evidence as he sees it of that. You were able to articulate your wants to different organisations, especially the Guinness Trust, and decided that you just wanted to return to London. That's to say that far from acting under a temporary aberration of mind, in serving notice to quit your property, you in fact acted rationally in vacating address from which you, whether reasonably or not, believed you were suffering fraud and abuse. I will deal separately with whether those matters, if true, stop the property being reasonable for you to continue to occupy. So, in a sense, he's making the point that the notice to terminate of itself looks like a perfectly rational document. It's perfectly understandable. Of itself, it doesn't suggest any inability to manage one's affairs or aberrations of mind. It looks lucid. And then his overall finding, paragraph 21, I'm satisfied this is a simple case in which you merely regretted moving from Brighton and then sought support to move back to London. And this is some of the kind of weaving. He then goes on to make a point about not having reported antisocial behaviour. Paragraph 22, he's not satisfied that the decision to give up the tenancy was a decision made because you could not make rational decisions at that time. And then at the bottom, it may be of some significance. You told Dr. Mannon, so that was the 2017 letter, that you had no option but to leave Brighton and return to London. For me, it is evident this is a simple case. You wanted to move back to London, and you realised that if you wanted to move back to London, you would have to terminate your tenancy, and chose to do this rather than try and settle in Brighton. So he's rejecting the no choice expressly. No, or no, put it in terms of no option. And then there's reference to evidence about what he was doing after he left Brighton as well at paragraph 23. Paragraph 26 applies in terms the paragraph of the Code of Guidance, the paragraph para C, and rejects that test on the facts. Then under the head, page 172, under the heading neighbours.
Since you're presumably not coming back to this, or are you going to come back to this in the context of the public sector equality duty?
No, ask your question now, my lord.
If you're not coming back to it, then we should notice paragraph 27, I suppose.
Yeah, although I don't place much reliance on that, because the question is what you do, not what you say. You know, in the sense that you have to apply a sharp focus, saying that you know what the PSED is may be of some limited value. But if you don't refer to the PSED at all, but you apply a sharp focus, that's compliance. I can place some limited reliance on the fact that he clearly was aware that the PSED exists and he had to comply with it. But it doesn't take me very far.
Yes, I've heard.
And then neighbours. So the basic point, the next part of this section of the decision is he rejects the allegations of harassment and homophobic abuse. He finds as a fact it did not happen. No challenge to that. And obviously that's linked with the point about, did he feel unsafe? Did he go on holiday to Europe in order to escape? And so, you know, there's a reference, paragraph 29. Back, been asserted your neighbours stole your bank card and this made you feel unsafe. And it's also been stated you received homophobic abuse and it's been subject to antisocial behaviour. And then it gives the kind of conclusion as a detailed assessment of the evidence, what happened. You can't separate this from the other parts of the decision. If, for example, paragraph 30, I appreciate you strongly believe it was one of your neighbours. Your card, it's understandable why you thought this was the case. So it didn't make your accommodation unreasonable to continue to occupy. And then paragraph 31 really is a bit more relevant to the other sections, because he says, I'm not disputing that with your pre-existing mental health issues, it may have been more upsetting for you, and you may have been less able to deal with it. But I'm not satisfied this meant that you were not reasonably able to continue sharing a building with your neighbours. And nor, as above, do I consider you fell into temporary aberration of mind, and so forth. And then there's a consideration of the evidence about whether or not he, 32, whether or not on the balance of probabilities he reported the non-bank card theft incidents to begin its partnership, decides he didn't. And then I've already referred you to the finding towards the end of paragraph 32 on page 173, which isn't challenged. So having decided that, as it were, objectively, the accommodation was reasonable to continue to occupy, he then goes back to ask himself the question, well, is it still the case, having regard to Mr. Bussandra's mental health? Paragraph 37, there was some criticism of this, that referring to his physical health conditions, but you may recall when I took you to the representations, they said it was unreasonable to continue to occupy because of his physical health conditions. So for completeness, he also refers expressly and in some detail to the physical health conditions. And then basically he goes through the reasons why it might have been the case that it was unreasonable for Mr. Bussandra to stay living at the Brighton flat, given his findings as to what really happened. And he basically says he was capable of independent living. He wasn't that reliant on someone to be his carer or for support. And that he could have accessed the medical services he needed in Brighton. That's paragraph 39. And that he was able to engage with new services. Paragraph 40. Making for actually, your condition hasn't improved since coming to London, and if you'd stayed in Brighton, it would have been better for you. So again, returning to the point that, you know, he's accepting that there was a level of anxiety and depression. So he says, I appreciate that given your pre-existing health conditions, this anxiety can be elevated, but the letter from Dr. Patel does not suggest to me the level of anxiety and depression, which are such levels that you are unable to make rational decisions, and or that it made it unreasonable for you to continue to occupy. And then paragraph 41 returns to the theme about Mr. Purdus's view that the evidence of what Mr. Bussandra was actually doing over this time does not support an opinion that he was suffering from a major depressive episode. So 42 again, it's that nuanced point. He doesn't exclude some effect on Mr. Bussandra's mental health. Not the same as saying that you staying in Brighton was having a significant impact on your mental health to the extent that it made it unreasonable for you to continue to occupy the accommodation. So, and hence the conclusions follow from that. See? Given this, now I move on to ground. Given the submissions I've already made, in other words, I say the test of deliberately is not the one that my learned friend advances in her respondent's notice. Her case is, and the case advanced below, before the judge below was, that the correct test is whether Mr. Bussandra's mental health impairments had a significant influence on his decision to leave. I say that's the wrong test. That's not the same as the test of whether he left deliberately. So I've already made my submissions on that. After that, there's not really anything left in ground one in my submission. The judge just got it wrong. The judge said something completely different. He said the real test is whether Mr. Bussandra had a real choice. And by focusing solely on mental capacity, or sorry, I'm using that as a shortening for the more liberal test in the Code of Guidance that Mr. Perdios actually applied. Mental incapacity or limited capacity. By focusing solely on lack of mental capacity or limited mental capacity, Mr. Perdios applied too narrow a test. But it's clear that he didn't, because the whole section of the review decision is devoted to whether it was reasonable for Mr. Bussandra to continue to occupy the Brighton flat in the light of his mental health difficulties. With my lady, we had an exchange about the extent of the overlap. I adopt her point, really, that by addressing whether it was reasonable for Mr. Bussandra to continue to occupy the Brighton flat in the light of his mental health conditions, that included whether he was forced to leave, had a real choice. It was subsumed in that. But for good measure, as I pointed out to you, he did actually specifically address the no option point in paragraph 22. That's my basic approach to these decisions, which I suggest is the right one for reasons I'll come on, is to look at the substance. It's not about whether someone actually refers to the test, it's what did they decide in substance. And in my submission, in substance, Mr. Perdios decided that Mr. Bussandra was not forced to leave because of his mental health. And the remarkable thing about the judgment below is the judge appears to have not realised that Mr. Perdios rejected the majority of Mr. Bussandra's factual case.
I mean, I'm conscious of time again.
Yeah.
You've very correctly been taking us through the review decision.
Yeah.
And that actually is our focus, isn't it?
That's,
so
in a sense, that's the end of the, you interpret that.
What I mean is not, there are various things that might or might not be said about the judge's findings in paragraph 60 to 65, but in a sense it doesn't matter. The question is the review decision open to criticism?
Absolutely. The only reason I'm addressing this point is because I think my learned friend doesn't entirely relinquish
Yes, I see.
this too narrow a test point, even if she's wrong in her respondent notices point.
Well, I assume she does maintain that position, but it doesn't depend on whether the judge was right about it. It depends on the substance of the argument.
Yeah, absolutely. So, but my submissions, you have to look at it as a whole, and if you look at it as a whole, he addressed all the three ways in which the mental health issue was run. no real choice. No or limited mental capacity, or not reasonable, continuing to occupy. That's the substance of it. So those are my submissions on ground one. Ground two. So ground two, as pleaded, is kind of kitchen sink ground, so it contains a number of different points. My understanding of the way it's really being advanced, it simply said that it was not rational for Mr. Perdios to disagree with Ms. Pisanesky's opinion that Mr. Bussandra was, at the relevant time, suffering from a major depressive episode and unable to think or rationalise clearly. That's my understanding. That's the substance. It's not actually a reasons ground. And there is a difference between a reasons ground and a rationality ground. Reasons ground said you didn't tell us why we lost. The rationality ground is you told us why we lost. The basis on which we lost was not rational. So there is a, and in my understanding is that's actually how it's put. It's a rationality ground. That's also how the judge understood it. So that. So I basically made my case. What the respondent says in this supplemental skeleton argument paragraphs 13 and 15. So they characterize this as basically the reviewer a straight clash between the opinion of the reviewer and the medical professional. I agree that Mr. Perdios rejected her view that he was suffering from a major depressive episode at the time. And I agree that he relied on his assessment of the bank statements and other surrounding evidence as to how Mr. Bussandra was behaving at that time. But it's not as simple as just rejecting a medical opinion. Because if you read both the medical evidence and the review decision as a whole, it is clear, first of all, that Mr. Perdios decided that the abuse and harassment didn't take place. Secondly, therefore, he didn't go on holiday to Europe because he was desperate to escape out of fear from his neighbours. Thirdly, therefore, the patient narrative given to Ms. Pisanesky was incorrect in fact. The information she was being given was incorrect. And therefore, fourthly, that undermines the cogency of her opinion. But I'm not kind of resiling from the proposition that just like a judge might hear an expert and reject their evidence, you know, for certain reasons, it'd be I accept it'd be difficult to do so if it's simply if the judge had no surrounding, you know, information on which to do so. But here it's absolutely crucial that the expert opinion was based on facts or factual account, which was rejected as incredible. And so once one views the review decision in that light, in my submission, it's eminently rational. There is no rationality point.
And that's probably a good moment to break.
Yes, and I know I have to speed up. I'll deal with the last 2 points probably together and very quickly. 20 minutes. That's fair to Miss.
I hope Ms Davies will think that still leaves her enough time.
Yes.
Good, thank you very much. In which case, 2 o'clock.
All rise if able.
I start.
Yeah, I passed it. I saw it didn't actually come off. I was wondering,
Am I getting undressed? I'm sorry, mine's in the back.
Go. Oh, yes, get your lunch.
That you got me in on that. Is Zacaroli still on the professional stuff? You get Zacaroli, like it.
You just dropped something. Is that what was holding it up?
That's the last one that just fell out.
No, we'll leave it here.
We can leave it here.
Whatever you like.
There are many ways in which women have a harder time at the bar, but